All right. Well, thanks, everyone. Welcome to tonight's Cap Times Talk featuring Wisconsin Supreme Court Justice Brian Hagedorn. Just a minute, I'm going to turn it over to our host, Katelyn Ferral, but I wanted to take a moment first to thank all the Cap Times members with us tonight. Your contributions are crucial for putting on events like this one, not to mention the reporting that we produce every day. Thank you so much. For those of you watching who aren't Cap Times members, you should know that membership comes with a number of benefits, including the option to pose questions to panelists at events like this one. Visit membership.captimes.com for more information on that. And while I have you here, I also want to make sure you knew that our next event is coming up on Tuesday, May 11, when we will have our very first Cap Times Live, sponsored by Monona Bank and featuring Natty Nation. The band will be playing at the High Noon Saloon, but we will be broadcasting that so you can watch it virtually. And a week after that, on Thursday, May 20, Lindsay Christians will be hosting another Cooking with the Cap Times with Dan Fox of Heritage Tavern. I'll post times and registration links for those events in the chat after we get started. Speaking of which, I'm going to turn it over now to Katelyn, who's our investigative reporter here at the Cap Times. Great to see you, Katelyn.
Hi everyone. Well, thanks for joining us. So I imagine if you're here, you probably know who Justice Hagedorn is, but I thought I would just introduce him a little bit. So Justice Hagedorn was first elected. He's a justice on the the Wisconsin Supreme Court. He was elected in 2019. And prior to that, he served on the Wisconsin Court of Appeals. Prior to that, he was chief legal counsel for former Governor Scott Walker. Justice Hagedorn has become somewhat of a swing vote when it comes to some key decisions over the last year. He attracted attention after he voted to uphold the results of the presidential election in cases brought by former President Donald Trump's campaign. And more recently, he voted with the majority on the court to overturn the state's mask mandate and Governor Evers' successive emergency orders during the pandemic. So I have several questions for Justice Hagedorn, but I wanted to let you guys know that we welcome your questions as well. And so if you have them, please put them in the chat throughout our hour-long discussion, and we'll try to get to those as we can. So I'd like to give Justice Hagedorn first the opportunity just to talk a little bit about his background and also his judicial philosophy, which I know is something that we often hear about when justices run for the court, and I think sometimes can get muddled between the reporting and public's understanding of what the role of a Supreme Court justice actually is. So if you want to start there, Justice Hagedorn.
Sure, thanks. Well, glad to be with you and to talk with many of you, and hopefully this will be an enlightening conversation. I certainly hope that it is. Just on a personal level, I'm just a Wisconsin guy. So born and raised here and love Wisconsin. So I'm married, I've got 5 kids, and so my day-to-day life doesn't look too different than too many others, other than my day job is a little bit different. Let me talk a little bit about my philosophy and the way I approach things, and I hope this comes out in my opinions, and look forward to some more questions on this. But when I think about what it is that I do, and Katelyn kind of walked through some of my past a little bit. I've worked in the political branches. I've worked for the governor, not doing politics, but in supporting his policy efforts as an attorney. But that's not what I do in the court. And I think this all goes back to what the Constitution is and the way it works. And that is, we have 3 branches of government. And this is basic civics, but honestly, it drives at the way I look at my job. And we've got a branch of government, the legislative branch, that both federally and in the state is charged with deciding what the law should be. And some of you may love what Congress and or the Wisconsin legislature is doing, and some of you may hate it, or have lots of different feelings on what they do, but that's the way the Constitution lays things out. And the main job of the executive branch, whether it be the president or the governor, is not really to do policy, though there is an element of that, but also it is to enforce the law. That's what to execute the law. That's where the word executive branch comes from. So when I think about my role, the job of a judge is not to be the final decision maker on every interesting or complicated legal question, but to decide disputes about the law and to do so in accordance with the law. So I am, philosophically, I've called myself, and I think I try to live it out, an originalist and a textualist. I pay attention to what the law actually says. And the basic reason for that is because the text is the law. The Constitution is law. And so what it says governs, not what I wish it said. The statutes that are drafted by people who are not me govern, and they are the law, whether I like them or not. And so that's how I try to conduct myself, is pay attention to the law and decide those disputes based on the law, regardless of my own personal views, regardless of my politics, regardless of how passionately I may or may not feel about a given issue. So that's a high level, maybe to get us started.
Yeah. One thing I had wanted to ask you a bit about too, just is, as I had mentioned to you in our correspondence previously, I think that when the press covers the court, it often characterizes the work that you do and the various wings and judicial philosophies of its members as conservative or liberal leaning. And I know that, especially, over the last decade or so, we've seen a huge amount of money be poured in from partisan groups be poured into Supreme Court races. And so I'm wondering what your thoughts are about just, do you think politicization of the court when it comes to the public's understanding of it and what we see during the races that get you elected to the bench, do you think that's a problem? And I guess I'm curious what you make of sort of the thought that people might think if Republicans endorse you and more conservative groups, pour money into your campaign, then they might think that that's who you're going to align with, or that's, how you're going to lean more. Do you understand? What are your thoughts on that?
Yeah. Well, so there's a lot of moving parts to that question. Let me go back. I think this is not something that's a decade old, but what we're seeing are the fruits of something that's decades old, at the very least. So, it used to be that courts did not have a central place in our democracy, in our public life. That just was true early on in our republic. And so you could count on one hand at the number of laws struck down by the United States Supreme Court between our founding and the time of the Civil War. And that's not where we are. So the most contentious questions were not always resolved in court. There's a lot of reasons why that changed. One of which is we had a big war, the Civil War, and the 14th Amendment in particular was passed, which has been interpreted to give maybe courts a bit more power and say over what happens at state government. But there's more than that going on. And let me just add to this, Alexander Hamilton in Federalist 78, if anybody hasn't read the Federalist Papers, I encourage you to do so to help understand kind of the nature of the problems that led to our Constitution. But he described actually the most dangerous branch of government that he was concerned about, and founders were concerned about, was Congress. The least dangerous branch of government they thought was the judiciary. So let me fast forward a couple hundred years. The reality is, in my view, courts have taken on a supersized role, and they have asserted more and more and more and more power. And to the place where right now what we have is every contentious question, it seems like, ends up in our courts. And that's, number one, that's really unhealthy for democracy. That's not how things were supposed to work. And I also think it's a bit of a power grab by courts in many respects. And so I think the tradition of courts being a place that was off limits existed for some period of time. But remember, even up until 1986, when Justice Scalia was nominated to the court, he was approved by the Senate unanimously, 98 to nothing. And that was in 1986. So what's changed? What's changed is that people have begun to see the court as a place that has at times used its power to further its own political and moral views in ways that I think are inappropriate. Oftentimes. And so now the courts have begun to be seen as just another agent in sort of the never-ending political battles. Now, don't get me wrong. We have a legitimate and important role to play in deciding constitutional questions, in deciding questions about the law where there are actually disputes. So all of this stuff about money, money that goes into elections, and about the parties that get involved, I think is actually sort of downstream from the more significant issues. They're the fruits of the problem, and maybe not the root of the problem, if that makes sense. So it is problematic, and I do understand why people sort of hope that if they support a candidate because that candidate seems to be maybe aligned dispositionally with the political views that they may have, they may hope for outcomes. But I hope that the court can earn a reputation, this court and every court, for setting aside their views to just apply the law regardless of who supports them. I understand not everybody's going to like that, no matter whether the right or the left, right? Because we all want the political outcomes we want. And that's just the reality in today's world. A lot of the criticism judges face is because people on the left and the right and in the middle all just kind of want the outcomes they want. But I think it's so important to understand that law and politics are not the same thing. And if they ever are, then you will find me standing up and advocating for getting rid of the judiciary.
So this sort of dovetails into another thing I wanted to ask you about that I wrote about earlier this year, I think, maybe it was last year. Time all blends together, but it kind of goes to this this sort of increase to some extent that we've seen in original actions. And I'm wondering if you can talk a little bit about what an original action is, and what your thoughts are. You sort of articulated them to me at the time that I wrote that story, but you've consistently talked about the role of the court being a modest one, not just in the conversation we're having tonight, but you talked about that in your written opinions and in other interviews that you've given. And I'm wondering if you can just talk about what you have seen since even just you've been on the court when it comes to original actions, and if you think sort of the increase we've seen in folks trying to do that and bypass lower courts and take a policy, everything's an emergency question kind of, as you these days could speak to that a bit.
Yeah, right. So there are three levels to our court system. There's two different court systems, basically federal and state. And in Wisconsin, we're structured the same way the federal system is. You have the trial courts, the Intermediate Court of Appeals, where I sat on, and then the Supreme Court as well. So the basic way the system is supposed to work is that you have an initial decision at the lower court level. And at the trial court level is where you have judges who find the facts, figure out what happened. The appeals court and the Supreme Court are not equipped to do that, and we don't do that as a general matter. So, and things work their way through the system. There's a lot of reasons for that. We have seen an explosion of original actions. Some of it I think is not good. Some of it is understandable. And I've written about this generally. So we typically don't take original actions. It was rare historically for this court to take cases in the first instance. Typically, if we do it, we're looking for, and by the way, I should say the Constitution gives us power to take original action, so there's nothing necessarily wrong about it. And quite frankly, there's also no law about this. We have some internal operating procedures and some other things that govern sort of the way we make decisions, but quite frankly, if four members of the court want to take a case, then we'll take the case. That's just the way these things work. So, and the Constitution gives us the power to hear original actions. So there's nothing illegal about it. This is more a matter of how you do law and how you do process. But generally speaking, we'd be looking for a statewide issue that is important, oftentimes timely. I would say that's an important component usually, though it's certainly not required. And where the lower court work is either not necessary because we don't need to find any facts about what actually happened, or because we maybe wouldn't benefit from going through that. We just need to get an answer. So one of the reasons we've seen an explosion of that, to be quite frank, is because we've seen some unique circumstances. So, the pandemic has raised a lot of really interesting, novel, and complex issues that probably need to be decided on in an authoritative way by a court of the state in a timely manner. So I have tended to have been supportive of more of those, but not all of them. And I would like to see us not operate on that basis, because we're not good at it. We're not meant to handle emergency motions. We're not meant to handle those questions. We're meant to slowly and painstakingly work through complicated legal questions that other people have thought about and vetted, that make their way up to us. That's the normal way things should operate. And so, I'd like to see us return to normalcy, but on the other hand, again, there's a reason why we've had a lot of really unique circumstances historically that have happened in the last year. And, those are probably legitimate reasons for us to sometimes step in and answer those questions.
Yeah, I'm wondering, just as far as how the process works, like when it comes to how the court decides whether to take an original action, I know that you have discussions among yourselves about that. I think it's just kind of an interesting idea to me because, of course, whether something is really how timely something is or necessary, important is going to really depend upon, kind of where you might sit ideologically on any spectrum or the lens through which you're looking at it. And I'm curious how you guys chat. I mean, do you sort of conference about that? And how does it work behind the scenes when you're working with your colleagues on
Sure.
whether to take?
Yeah, well, and certainly, again, these are judgment calls you make, right? Judgment calls that are weighing sort of all these issues. And I should add one other thing. When I have something that is an emergency or politically controversial, I will say that my first inherent tendency is to put the brakes on, because most of what, to be frank, is on the front pages of the newspapers isn't necessarily a legal emergency. There's a lot of political emergencies. They're not legal emergencies. And we don't need to solve every political emergency that happens. So what happens when a case comes in is we do have court commissioners who work for us. They often assist us in thinking through these questions, looking at how we've historically handled issues. And yeah, we will meet in dialogue as we'll conference and talk about whether we want to take the case or how we want to approach it. We can take the whole case, we can take certain issues, we can add issues to cases to make sure we have what we think we need to have on that. So yeah, there's lots of ongoing discussion about it, and just like any other issue that comes before us.
So one thing I had wanted to ask you about, I don't know if folks know this generally, but prior to becoming a member of the court, I know you were a clerk for former Justice Michael Gableman. Yep. And I'm wondering what that experience was like for you, and sort of how that experience has shaped your approach as a justice, knowing what it's like. I know clerks do a lot of work, and that it's a really busy job. And so, yeah, how did that shape what you do now? And how do you think the court has changed from your experience as a clerk quite a while ago to now being a justice?
Yeah, actually clerking was probably the first time I ever really thought about being a judge. I mean, it may seem odd to people, but I don't think that was really even on my radar screen as something that I'd really like to do. So, the practice of law can be fascinating, and it can be also tedious. And when I came here, and for those who don't know, we have a very small chambers. So I have 2 law clerks who work for me. You get 2 employees who work for you directly. Historically, you might have had a judicial assistant performing more administrative or secretarial functions, along with a law clerk. It is actually much more common now for justices to have 2 clerks, since the administrative load is probably lighter historically than it used to be for probably just normal advancement and productivity reasons with technology. But not everybody follows that model. And so you work very closely with the justice, though it depends how the justice wants to use you. And Justice Gableman was a great friend and mentor, and so I get to work with him very closely on cases, helping draft opinions, helping think through the questions, obviously getting to know all the members of the court as well. So I really loved the law. I really my love for the law bloomed when I was here. That's how I would describe it, honestly. I just found myself, pinching myself that I got the opportunity to work in such an amazing place, in a beautiful building, working at this court, and to help serve the people of Wisconsin. For me, it was just a real privilege, and I just loved it. I thought, wow, I would love to do that for a living. That would be just fantastic. How has the court changed? Well, the court was, to be frank, not at a very healthy place when I was clerking, which was right after Justice Gableman was elected. And there were, lots of disputes that happened around that time, and I don't want to go into all of those. I will say that the court has gotten much healthier than it was. I mean, we still have our things we need to get better at, but the culture is stronger than it was. It's more open. The dialogue, I think, is better than it was from my limited vantage point at that time. And so, one of the other things, and this is actually something we as justices have begun to talk about. It used to be, though, that every member of the court was in the office pretty much every day. And so that doesn't happen anymore. And certainly in the pandemic, So I have some colleagues who I have not seen in a year. And that is probably not great for a court that works together. No, we're talking all the time. When we meet and we do conference, and you can do phone calls and emails. So there's lots of communication, but there's something that's missed. I think anybody who's been stuck on Zoom for the last year knows that's wonderful, but it also has some limitations. There's something to interacting with each other personally that I think would probably benefit us as a court. And we have justices who are not always around simply because they're living further away. It used to be that justices typically moved to Madison. I have not, but I am in on a regular basis still and have been most of the last year. So that's something that's just different. And I think, in a new technological age, learning how to work efficiently and productively, in that sense, we're maybe not a whole lot different than most people who are listening and trying to figure that out too.
Yeah, it kind of struck me as you were talking about those kinds of relationships and the dynamics of working with colleagues, is that the court is sort of an interesting entity in that you really have to work together with folks who you might really disagree with strongly on what you see as super important issues. And, people always kind of cite the US Supreme Court example of like the Ruth Bader Ginsburg and the Scalia friendship. I mean, do you have friends who are on the court on opposite sides of the aisle? Or do you, like, if you could, like, do you guys want to get together and sort of be friendly in that way? Or is it really like pretty much business? And, have you gotten to know them as people? And has that, I don't know, shaped you in this moment where people are so polarized and kind of boxed in, to their own siloed views?
Right. No, that's a great question. Well, I don't like the opera, so I haven't been able to invite anybody to the opera, which Lily used to like to do with Ruth Bader Ginsburg. But, yeah, I mean, first of all, I would say the pandemic has made some of that challenging. And remember, this is only my second term on the court, so I've only been a justice for about a year and a half at this point. But I certainly talk with my other colleagues all the time. And this is something, to be frank, that I think we need to do. We did grow as a court. There were a lot of strained relationships. It's no secret. I'm not, giving any inside baseball, from years past. And I think we're moving past that, as a court, which I'm grateful for. So I get along very well with, with I think all of my colleagues. I mean, Justice Karofsky, who's just joined the court here, and Justice Dallad, who came in the year before me. We probably voted for different people in recent Supreme Court races, but I get along really well with both of them, and we have really productive conversations about cases and about the law, and also outside of that as well. So I'm looking forward to doing much more of that. When I started, we made an effort to sort of pick up some lunches, with other members of the court. The U.S. Supreme Court does that regularly. That's not been part of our tradition, but it probably should be. And so I'm looking forward to, engaging much more as people feel more comfortable being present in person. So in Zoom and in physical distance is something that has made that challenging, of course. Yeah.
Yeah, I kind of forget. I think that it really you haven't been on the court, a super long time, and that the pandemic has really dragged on a long time for now. So, I'm wondering too, maybe if you could just briefly talk about, I know you don't have any details, I guess, on what we might see coming up, but, we're going to have, as obviously a new Chief Justice, and the justices vote for who they want to be in that role. And I know, there's been issues and big changes surrounding the Chief Justice and how they become the Chief Justice on the bench. And so could you talk a little bit about just that role broadly and why it's an important one, like important enough to change the state constitution to, to deal with it on the bench? Right.
Well, I did support the change to the Constitution. I think, we are a body that operates. We're a small group of people that work together, and it's important that our leader be somebody who people, at least a majority of the court, can trust, and is going to, build and lead in the right direction. And merely because you've been around for a long time doesn't mean you're good at that. So there's nothing inherently about the way the Constitution used to be structured is that if you were the senior justice, you become the Chief Justice. And that may not work if that person is not a strong leader in terms of building the kind of culture you want on the court. So yes, so Justice Pat Rogensack has been our Chief Justice for the time that I have been here. And, I think she's done a very good job. Justice Ziegler will be taking over here. I guess this week, May 1st, I think is officially sort of when she begins doing that. I will say, unlike the United States Supreme Court, the Chief Justice role is not one that has any power when it comes to deciding cases. So people often think of the Chief Justice in that role. People may know that at the United States Supreme Court, if basically the way opinions are assigned is if you are the most senior justice in that group, the majority, the minority, you assign who writes the decision for your group. So Chief Justice Roberts, if he's ever in the majority, he gets to decide who writes those cases. And that's a huge and important power that can greatly affect the way those cases come down. That's not true on our court. At our court, it is, we actually pick numbers out of a really awful kind of St. Patrick's Day hat, like this green St. Patrick's Day hat. I don't know why or where that started. I think Justice Crooks, I heard, brought this hat in. And so we literally draw numbers out of a hat if you're in the majority and you write it. And so you don't have decision-making power, but it is an important position because you are constitutionally the head of the whole court system. A big part of our responsibilities is administering and thinking about the court system globally. So we manage the budget, we regulate the profession of law and attorneys. And so there's a lot I think you can do from that position if you use it well to improve the administration of justice, the efficiency, the use of taxpayer dollars, and hopefully, ensure that our courts are doing better and better, doing what we ought to be doing justice, for the people of Wisconsin.
Yeah. So I wanted to ask you, I'm kind of zigzagging all over the place here, but I wanted to ask you a little bit about what it was like for you, I guess, over the last several months when you were sort of a pivotal swing vote, not sort of, you were, really a swing vote in some of these really consequential decisions that dealt with the presidential election primarily, but also the pandemic. You did a lot of interviews and with, a variety of, outlets kind of talking about your views and were really lambasted by folks in conservative media and folks, on the left, suddenly thought you were okay. And so I'm wondering what you think about that. I mean, do you view yourself also as a swing vote, and what was it like to be you during those weeks when you probably knew you were writing something that was going to obviously, be of consequence and be controversial.
Right.
So
right.
What's that like?
Yeah. Well, first of all, I really don't think much about people's views of me. I don't think that ought to govern too much of what I do. And I want to reiterate that when I make decisions, I really do care about the law. I mean, I've got 5 kids, and so I still help my kids with their math homework. But in math, you gotta show your work, right? And so that's what we do as justices. We show our work. And I hope when people read my opinions, they'll see I'm not really talking about good policy, bad policy. I'm trying to follow the law, and that can get complicated, and it's not always easy. But I didn't vote the way I did. I just want to reiterate this point. I didn't vote the way I did in any of the cases that have come before a court in the pandemic or in the elections because I supported any candidate over another, or because my judicial philosophy changed at all. I voted the way I did precisely because I was trying to implement my philosophy. Just follow the law, and not treat this case different than I would treat other cases. Not let the politics of it, influence it. So. Yeah, and I did speak, and I do enjoy taking the opportunity to speak, not because I'm not so much thinking about my election in 2029 or something like that if I choose to run again, but because I think it's really important to talk to citizens, and I do that all the time about what the role of the court is, and is a unique opportunity, I guess, for me to do that. It's certainly been challenging. I guess the only thing I will say about it is this. I hope when I ran, I said regularly that you should not be able to predict how a justice is going to vote on the basis of their political supporters or their own political views. Now, judicial philosophy might be a different question. So sometimes judicial philosophy, you should be actually kind of predictable based on the basis of your judicial philosophy. But I think when people come to our court, I hope one of the takeaways for members of the bar, members of the public, is that regardless of what my personal views might be on an issue, I'm going to, as sincerely and with all the integrity I can muster and all the courage that I can muster, I am going to focus on what the law says. So I, to the extent it shapes the arguments that come before the court, that to me is an encouraging piece, because it does. If people think that Justice Hagedorn's vote is in play and that it could be determinative, then they're going to make arguments that I care about. And I'll tell you what I care about. I don't care about your policy arguments. I care about the law. I care about what the Constitution actually says. I care about the original public meaning of it. I'm not here to support a Democratic agenda or a Republican agenda, even if I have thoughts about all of those things. And so that part, I guess, is maybe one positive takeaway. I will say there's a little bit undue attention that I get because of it. And the media, I think, sort of sometimes likes the intrigue about all these things. But so I was talking to a Court of Appeals judge recently who was reveling in the relative anonymity of that role, which was nice when I had it. So, you know, I don't care so much about the media or what people's perceptions of me are. I just want to be faithful in what I've been given to do.
Yeah. So we had a few questions come in. I thought I would bring one to you. One just asked, so there's a discussion that redistricting may end up at the Wisconsin Supreme Court. Can you discuss the court's role and how you and the court might approach the redistricting issue if it does arrive before you?
There's not a lot I can say about that. I understand there's a lot of interest in that issue. We do have a rules petition currently before us, asking us to create a new structure related to when and if a case would come to us. We have not released any decision on whether to grant that rule petition or deny it or say anything about it one way or the other. So, but you know, if a case comes to us, we'll have to make a decision at that time with whatever structure we may or may not have in place at that time, whether we want to take it or not. So, you know, the cases are often filed in federal court. They can be filed in state court. There's a lot of history here that goes back a number of decades, and of the sort of court involvement in redistricting is relatively new in American history in the last 50 years or so, in part because of court decisions. That you know makes things more complicated. Do
you have any sense of how long it'll be before the court will issue a determination on that petition?
Yeah, I can't give any information on that at this point.
I'm curious, I guess, what your thought is. So, I mean, folks talk about, and I hear it, I guess, more too at the federal Supreme Court level that, you know, of course, deciding not to opine on something is sort of, people perceive as sort of like opining on something by tacitly allowing it to continue. And that can go for a variety of issues. And so I guess, what are your thoughts on that there's power, of course, in your writing and you guys making a decision, but there's a lot of power when you know, reject a petition like this on any number of things. And people, how might you respond to someone who would say, well, that's just a tacit approval of what the status quo is?
Well, there's a lot of things that go into these sorts of questions, including, you know, any given case. So, I mean, think about let's put it outside of redistricting or other cases like that for a moment. You know, when if we get, for example, an original action petition, I may think it's a really important question that would be really good to decide, but for other practical and judicial process reasons, it wouldn't be prudent for us to do it. So I may agree with the arguments, at least at first blush, right? So I don't know that you can read too much into what you take or don't take. I mean, you can sort of guess and speculate, but it is just sort of at the level of guessing and speculation. Some of it will depend on, you know, whether, you know, courts, you know, the U.S. Supreme Court, you know, Do you think you're likely to get a majority that's going to actually do something beneficial for the clarification of law? You know, one of our roles, one of our main roles on the Wisconsin Supreme Court is to clarify the law. So we take all hard cases, we take the cases where people disagree, we take the cases where maybe the law isn't clear, or maybe the Court of Appeals has pointed out that there's some inconsistency in the way decisions have come down. So that's the kind of stuff that we're looking for. There are lots of cases where I might not like the lower court outcome, or I may agree or disagree with the arguments, but we may or may not take the case. So it's really hard to say, you know, hard to answer that at a general level.
Yeah. I have two kind of processy questions I'm wondering if maybe you can answer in a nutshell, but I'm wondering first, like what it's like and how you decide what kinds of, when attorneys come before you and the court hears cases. And so, you know, for folks watching, I think a case will make its way to the court, and then there will be oral arguments where attorneys come before the court and they make their case, but often it's where justices are asking them questions and we're like grilling them on certain elements of what their case is. I'm wondering like how you decide what kinds of questions varies case to case, but if you decide that ahead of time, again, there's dynamics I know at the federal level about certain justices who speak a lot or never speak, like Clarence Thomas, and what's that dynamic like? And then also I'm wondering if you could talk about then on the back end of that, your writing process. I think your opinions are really clear, and you often, I think, do a good job of walking people through your decision and how that harkens back to your role. And I'm curious just what that process is like, and if that's a really intentional thing on your part.
Yeah, thanks. In terms of oral argument, every justice probably has their own philosophy of what they do. There are justices that could be described as inquisitors, out there. There are justices who might really want to drive home a point for one reason or another. I can tell you what my approach is. Generally speaking, I'm seeking information on the questions that I have. So I'm typically not trying to make some sort of broader point or make some point for the press or something like that. I ask questions that are geared towards my analytical process. And usually, again, by the time we have an oral argument, there's been a lot of preparation on the front end of that. There's reading the briefs, talking about it with my clerks, maybe my colleagues. So there's a lot of prep work that goes in ahead of time. And usually what I'm looking for is, okay, your argument is this, but what does this mean? How does this apply? How does that logic play out down the line? Or how does this affect other things? Or here's something I felt like was incomplete in your briefing. I have this question here. How do you explain this issue? You didn't fully address this argument that was raised. So, for me, it really is a wonderful sort of intellectual exploration of the law to try to get to the answer as best I can. So on the front end, in terms of the writing process, I work really hard at that, and I'm glad to hear my opinions are clear. It is, I think Justice Scalia, somebody said he was just a phenomenal writer, and I'm no Justice Scalia, but I said, well, it must come really naturally to you. He said, no, a lot of blood, sweat, and tears. So, and certainly that is my process. I am pretty ruthless with myself. So I will do a lot of first drafts myself. My clerks will assist me with some drafts, and we go back and forth and back and forth and back and forth and back and forth until we're ready. And I instruct my clerks, it's your duty to tell me if you think, well, number one, I think I'm wrong on a case. It is your job to tell me you think I'm wrong. If you think my argument isn't clear, if you think this really cool turn of phrase that I was excited about doesn't work in the opinion, then you need to tell me. If you think my tone is off, if you think the reasoning isn't strong, if you think it's there, and quite frankly, I try to model that for myself. I do that to myself, so I edit myself pretty ruthlessly. So we go through lots and lots of drafts, typically on the dozens aside for a majority opinion that will come out the door. And yeah, I really, when I remember reading cases in law school, I often felt like judges would hide the ball sometimes. Just to be real honest with you, there's something else going on here that they're not really telling you. they have something else in mind that's not really in the pages. So let's try to figure out what it is. I hope my opinions don't do that. I don't think that's right. I don't think that's what we ought to be doing as judges. And so some of it, I hope, also goes back to my judicial philosophy. Because I'm not doing a lot of balancing and whether I think this is good or bad. I'm just, all right, let's start and figure out what the law is. Here's how the law is. Here's how it applies, and really be transparent about that. And I am mindful of my audience as well. And I have lots of audiences. My audience includes lower court judges and attorneys who need to take these opinions and apply them. My audience are future justices who might agree with me, sometime down the line. My audience is to some extent the general public on a few cases. So yeah, sometimes I do go out of my way to explain complicated legal concepts in a way that the average person can understand. And that's a common refrain sort of internally in the writing process. I think that's, really important. And so I love writing. My daughter, my youngest daughter, she's 7. Somebody asked her maybe 6 months ago, what does your daddy do for a living? And she said, he writes, which is about right. That is I read and I write. That's my job. So different kind of writing, than you do as a journalist. But I sweat over every word. So.
Yeah. Well, I mean, and I'm biased as a journalist, but I think that, I know I don't cover the court super regularly as a beat because I jump all over the place. But anyway, it's enormously helpful in trying to, I think, thoroughly and as fairly as you can sort of package the philosophy as well behind what you're arguing, because I think it can often get conflated. And so as my job is to explain to the public what's going on and all of that, I think those types of opinions are helpful rather than being really steeped in case law and kind of, all over the place. So I appreciate that.
I do tell my clerks, just because we're lawyers doesn't mean we need to be bad writers. So, good writing is an interdisciplinary thing. And lawyers, even though we tend to write for a living, can be really, really bad writers. So, there's no reason why the law always has to be boring. Sometimes it is a little boring, but, there's no reason why it always needs to be that way.
Yeah. Well, so we had one person send in a question he's a law student, and he wanted to know how your legal education really shaped your development as an attorney and a judge, and if there are any things that you wish you could change in legal education to help develop better lawyers and advocates, especially ones that come before the Supreme Court. And I'm curious too about that question, and also like why you do love the law so much. Like, what is it about the law that you love? And maybe that comes into play in law school, or maybe it was as it bloomed later. But anyway, if you could talk about those things, that would be great.
Sure. Yeah. Good questions. So in terms of, law school, one of the things I did, I'm really glad I did in law school, it was sometimes less the classes, but I went to these lunchtime events all the time. I was the president of the Federal Society at Northwestern, and I was so very involved in putting on events. There are ideas in law schools that tend not to get airtime. And so one of the things we would do is give those ideas airtime and I have debates, and that was wonderfully informative. But I would go to lots of the different events. There were all these student organizations that put on events, from the Black Law Students Association to the Women's Law Group and whatever else. And so you have a lot of interesting speakers and ideas and engaging with really smart people. That was helpful to learn how to think well, to learn how to, analyze well. Law school generally, I think law school needs to grow quite a bit. We pretty much do law school like Harvard did it in 1860, and lawyers are really, really slow to change things. There's a whole lot I think that law schools can and should do better. Not the least of which is training law students how to be lawyers, because oftentimes it is steeped in sort of generic, big picture questions on case law rather than nuts and bolts of what it actually means to practice practice law. And I think it's different at different places. I went to Northwestern, obviously it's a good school. The first assignment I got when I was an attorney was to draft a complaint. It's the way you start a lawsuit. And I was struck by the fact that here I've paid $170,000 for my law school education. I'm going to be in debt for the next 30 years. And I had no idea how to draft a complaint. Like there seems to be something off with that, a little bit. So there's a lot more probably to be said about that. But, I think the best thing I can say about law school is take advantage of the people there, because there's a lot of just smart, capable people, and that's how you learn. Your second question, Katelyn, was again I've forgotten. I'm sorry. It was.
Oh yeah, I'm sorry, and I kind of mashed them all together.
Okay.
I'm wondering what it is about the law that you love so much, because I just note that you mentioned that in a variety of ways. And I can tell it's effusive. So. Well,
that's good. That's good. I don't know. I guess I'm just kind of a big nerd about the law. I mean, I listen to podcasts all the time and debates about issues. I read about it. I follow what's happening. I follow the latest scholarship, legal scholarship. So law connects with, at a very essential level, who we are as human beings and the way our world works and operates. And so maybe the interesting thing about law is that it's so central to life, into every part of modern life. Some parts are probably unhealthy. That's the center of so much, but law connects you to a lot. And I'm also, to be honest, probably just an intellectually curious person. I'm one of these, my wife and my kids make fun of me because it doesn't matter what size phone I get, my phone will lock up because I just have too many podcasts that I end up downloading, because I just find so much so interesting. So my hard part in life is narrowing down my interests. But I also love the big questions. I love the hard questions, like what is law? What is the Constitution? How does that fit in? What's the judicial role? The great thing about this job is I get to think not just about the nuts and bolts, but about how they fit in together and how we go about doing our job. And I don't know, I'm not sure why. I think it's just wonderfully interesting and fascinating.
Yeah, so I'm gonna just throw a few of the audience questions at you, if that's fine with some of the time that we have remaining.
Yep.
So we got one question from a participant who said, should the Black Law Students Association have the same input to the judicial selection process as the Federalist Society? And so I'm wondering if maybe you can speak to that and or maybe broader issues when it comes to diversity of a variety of ways within the court system and on the bench in general.
Yeah. Well, the Federal Society is actually quite a big tent, an underappreciated fact about the Federal Society. There's some agreement on some basic core principles about the rule of law, the separation of powers being central to the way we go about things. And predominantly it is a network, of people. So it is true that in the Trump administration, the Federal Society had, I think, a lot of input. But part of the reason for that is because most people who are coming of age and of judicial age at this point were people that let me just be frank, if you didn't accept sort of the liberal status quo about how you should approach the law, which to be honest, oftentimes was just, does this accomplish whatever sort of the latest social justice movement might be, however good or bad that might be, there was one place to go in law school, and that was the Federal Society, where you'd find people who didn't think in lockstep about it. So, as I was a president of the Federal Society, I had the president of the ACLU was also on my board. So we were quite a diverse group of people from all different backgrounds. So there's nothing about the Federal Society that is necessarily monolithic in terms of the way you think. And I think it's great that an organization that's dedicated to the rule of law and separation of powers had an influence in who becomes judges. And when I was in the governor's office, I oversaw the judicial selection appointment process, and worked with Governor Walker. And if there were people who were connected to these big ideas, wasn't so much looking for outcomes, but people understand how to read about the law. I thought that was really important, and that mattered. So, and in terms of who else should weigh in, that goes to what you think a judge ought to be doing. So if you think a judge isn't there to just sort of assure certain policy outcomes, or necessarily to reflect society in certain ways, and by and large, I don't think that's our job. I don't think that's our job. I think our job, by and large, is to apply the law, whether doesn't matter what your background is for that. So I'll leave it there. Maybe if you have more specific questions about that, I can take it as a follow up if you'd like. But,
yeah, and everyone who's listening, feel free to type in some questions, and I'm happy to send them over. One other question we had was, who should decide the issue of a judge and whether they should recuse themselves from a case? Should the judge decide that, or should it be up to an independent panel? I know right now, I think it's the judge, right? I mean, maybe you could talk a little bit more about that and your thoughts.
Well, there's a number of complex rules in that. So there's a statute. There's also a judicial code of ethics. At a lower court level, there are other mechanisms to maybe override the decision of a judge. But at the Wisconsin Supreme Court, we would make that final decision. And the same is true at the United States Supreme Court. That's exactly how they operate too. It may not be a perfect system, and I understand there's been criticism of that in the past. On the other hand, I hope folks could understand an alternative argument, and that is that in today's world, people will use every measure of power they can to win these cases, and using recusal as a weapon to knock judges off who you think would be not agreeable to the perspective you want to offer. Not only could happen, I promise you it will happen in every case if there were easy mechanisms for going above and beyond that. So I don't know that there is a such thing as an independent panel. I think at the very least, as elected officials, people, the people of Wisconsin can decide whether we've made right decisions or wrong decisions on that. And also at the Supreme Court level, we really do have an obligation to hear as many cases as we can. At the Court of Appeals or at the Circuit Court level, another person can step in. At the Supreme Court, they can't. And so I think, we have a somewhat unique role. And again, this is the way the United States Supreme Court works too. If you've got a case that you want to bring and you don't want Justice Sotomayor to be on the case, I would feel really uncomfortable with an independent panel telling a duly appointed United States Supreme Court justice that she can't sit on the case. It would quite frankly lead to further politicizing of the court, in my view.
One other question we had that I think is an interesting one is this. It says you talked about the fact that your role is to interpret the Constitution as it was written. Do you encounter instances such as with telecommunications or privacy issues that may require added extrapolation beyond the strict language that's within the Constitution?
That's a wonderful, wonderful question, and I'm glad it was asked. And let me say a couple things about that. So simply because I say my job is to sort of apply the law and apply the text as it's written, that doesn't mean that that's easy. And it also doesn't mean that somebody who also is trying to do that might not disagree with me at the end of the day. So we might reason through things together because, laws are written by the legislature, and sometimes they might have written something confusing because they're written by people. Right. And so the law is not always particularly clear. And there's also really, really hard questions to figure out sometimes. What do you do with vague constitutional language, guaranteeing due process of law, for example? How do you handle those questions? So I don't want to suggest that being an originalist or a textualist means that gives you a clear answer all the time. It does not. And there are many times when you do need to find some workable way to take what's there and to apply it. So for example, we had a case recently dealing with the Second Amendment, and I was in dissent on that case dealing with felons. It dealt with whether somebody who had committed not pay their child support for 180 days, which is a felony, they're prohibited from owning handguns in Wisconsin for life. And I went through a pretty extended separate writing, going through some of the history of the Second Amendment as I understood it and trying to apply it. And what I also understood is that the language of the Second Amendment is sort of vague. And so you need some sort of interpretive framework to make sense of it. And we do that all the time as judges. But I think it's really important to understand that that's what our task is, right? So if you, and I would say this to the listening audience, if you cannot think of that cases that will come before the Wisconsin Supreme Court or the United States Supreme Court in the last year or two, and if you're somewhat of a political watcher, if you do not find probably more than one case where the political outcome that you desire is not the legal outcome that you think ought to happen, then you're probably not thinking about the law appropriately. That with the very least, you ought to recognize that there's going to be a divergence there between where you want the law to go and the way it actually is. And hopefully we can have an agreement, and I'd love to see us do this more and more, about what we're trying to do. So even if I'm interpreting a case in the Second Amendment, what I'm trying to do is figure out when the people of the United States put in their Constitution that there is a right to keep and bear arms, I have a duty to interpret and apply that in a faithful way. It doesn't matter what I think about gun control or firearms. What matters is what's written and what that means and how do we apply it. So we can have a shared goal, even if the reasoning, even if we might disagree at the end of the day, and do so in good faith, even from the same, judicial philosophy.
Yeah, let's see if there's any other questions here. I know we're coming right up on time. One thing, I guess, one last, you're welcome to add anything or make any notes that I didn't ask you and that you think is important for people to know. But one thing I thought I'd ask you about, because I know it was written about a bit when you were running for the office, is just the role that your faith plays in who you are as a person and in your life. And I was wondering if maybe you could talk a little bit about that. And if there's anything else that you're interested in just sort of sharing about that and how it affects or it doesn't affect the job that you do. And yeah. Well, thank you. And I will say, even when I ran, despite what you might read about, I didn't run on my faith, and I didn't run on that helping to determine where to decide. And unfortunately, I think my opponents and those who opposed me made that an issue for ways that I hope the people of Wisconsin have sent a message, and I think that's really inappropriate. That, believe it or not, you can be somebody who had a background in Republican politics. You can be somebody who is an evangelical Christian, and you can actually be a really, really good judge at the same time. And I hope people can accept that and believe that I can do my job with integrity. Let me just say, for me, it doesn't change the outcomes of cases, because I'm not, again, there trying to enforce my own views on things. And it doesn't matter whether you're a Christian or whether you're a Muslim or whether you're an atheist or what your views are. We've all got them, right? We've all got a worldview. We've all got a way we think and look at the world. But, for me, my hope ultimately isn't in this life. And so I think it really gives me a freedom to live this life with joy and courage and a bit of a reckless abandon for what really matters, in life. And so I think it allows me to eliminate the distractions and allows me to want to treat, everybody hopefully with dignity and respect and honor them, because everybody's been made in the image of God. And ultimately, have hope, as a Christian. Jesus for me is the center of my life as a person, and that helps give me fuel every day to really want to genuinely serve. And I guess I'll just say this. There might be people listening who didn't vote for me. I imagine there's quite a few, and that's just fine. But I hope you'll read my opinions, and I'm sure I'll get a lot wrong, and you're welcome to criticize me for getting cases wrong, I'm sure. But I will say that I come in here every day, and it's an honor to be here. It really is, and that I'm trying to do my job with integrity. At the end of the day, when nobody's looking, I want to follow the law as faithfully as I can, whether I like the result, whether I don't like the result, whatever criticism I get. And I want people to know that it doesn't matter what your background are, but what your policy views are, that's how I'm going to try to do my job, day in and day out for as long as people of Wisconsin allow me to serve. Well, thank you again so much for joining us and for taking the time to talk with us, and your accessibility, I think, to the public and the press in general. We really appreciate it. Sure. Well, thank you. Glad to do it. And I hope everyone has a wonderful evening. Stay safe. Yep. You too. Thank you. Bye, everyone. Thanks for joining us.